2023 CR 10633, State of Texas versus Devin Heflin. Could I have parties announced for the record for the state? Defense.
Or Alexander for Meredith Chacon for Mr. Heflin.
And are you Mr. Heflin?
Yes, ma'am.
Any objection to this attorney standing in for Ms. Chacon? All right, so what is happening, Mr. Heflin, is this is an attorney that works in the same firm as your attorney, Ms. Chacon.
Yes, ma'am.
My understanding is that a plea bargain agreement has been worked out between Ms. Chacon and the state. All right, so Ms. Chacon probably had to go to another court. So this attorney is standing in for her. My understanding is that this attorney is not here to change your plea bargain agreement. He's just here as an attorney standing in for Ms. Chacon so that the plea can be completed. If you would like, we could wait for Ms. Chacon to come back, or either you can go forward with this attorney. Which do you prefer?
You said you work with her? We're in business together. You know on her case, though? Yes. She was mine.
All right, do you want to speak with him?
Yes, ma'am.
All right, if you all will step back and talk to each other. Okay,
Sorry,
all right,
I had to take comments.
no problem. And for the record, for defense?
Meredith Chacon for the defense, Your Honor.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your
Court will find that the state is in compliance with discovery. Is there an application in this case?
Honor. No, Your
All right, Mr. Heflin, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am. I did understand it.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Heflin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punish family violence. Did you understand if I find that there's family violence and that this is a case of family violence, and I enter an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand?
Oh, yes, ma'am.
And did you understand you would not be allowed to be designated as primary custodial parent? Did you understand?
Yes, ma'am.
All right. And also, if I find that there is a deadly weapon involved, there will be an affirmative finding of deadly weapon. Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
State,
Yes, ma'am.
defense.
Yes.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting no contact with Kaydin, Kaydin Butler and James Butler, affirmative finding of deadly weapon and affirmative finding of family violence. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Standard procedure exhibit 1 with all attachments. And Your Honor, we have no objection. I have gone over the attachments.
All right, I'm showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Also, I forgot to ask, are y'all proceeding on both counts?
Yes, Your Honor. Yes.
And are you pleading no contest to count 1 and count 2?
Yes, ma'am.
And are these counts to run concurrent?
Yes.
The court, no problem. The court will review states exhibits 1 and attachments for sufficiency. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client was on a parole that had been transferred here to Bear County and would like you to give him credit for that time to run concurrent as well. The state had no objection, is my understanding. No, Your Honor.
All right, and which, do you have a cause number or anything? And the court will find you guilty of count 1, guilty of count 2.
And for the record, Your Honor, the victims are also aware of this, Your Honor, and in agreement with this. And I do have the case number whenever the court is ready.
Okay. Count 1 and count 2 will run concurrent. And then what is the cause number for parole?
19 CR S 238347. It's out of North Carolina.
All right, and the court will give you credit for any time served in that cause number, and credit for any time served, of course, in this case. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Caden Butler and James Butler. And I'll sentence you to 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not in the state, Your Honor. No, Your Honor.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea, because I followed your plea, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed, and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
20. I just turned 21 2 days ago.
All right, so I don't know what was going on with you at the household or what's going on with you in your life. If there's a mental health issue or anger issues, that's something that you're going to have to work on. Otherwise, you may find yourself living in a prison. You understand? And when you get to the point in Texas where they stamp you as a habitual, that means in some cases your minimum sentence is 25 years. You understand? All right, do better, okay?
Well.
All right, good luck to you.
Good luck.
Appreciate it.
At just 20 years old, Devin Heftlin stood before a Texas judge facing charges that could change the rest of his life. What started as another court hearing quickly turned into a harsh lesson about consequences. After reviewing the evidence, the court found him guilty on 2 counts of aggravated assault with a deadly weapon. Despite a plea agreement that capped his sentence, the reality of prison suddenly became very real. The judge listened carefully, granted credit for time already served, but made it clear that violence and poor decisions would not be ignored. Then came the moment that silenced the courtroom. 7 years in prison, an affirmative finding of family violence, and a deadly weapon designation. Before ending the hearing, the judge looked directly at the young man and delivered a warning that echoed through the room. If he failed to change his path, Future mistakes could lead to decades behind bars. As the courtroom doors closed, one question remained. Would this sentence become the turning point that saved his future, or only the beginning of a much longer journey through the justice system?